Yo, make sure you got your paperwork straight. I got Mickey the Truth.
Let's get one thing clear. This your girl, Mickey Truth. South Carolina, 803 to be exact. What's up, y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment, educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So
the loudest is the weakest. Give a fuck about what they scream.
With the YNW Melly case, you know, the last time I did an update on the case, it was in regards to the upcoming trial. And, you know, that's on hold until further notice, until a decision is made. We haven't really touched on the witness tampering case. And it's been some movement on that case. This will be my first time really looking at the actual documents. Shout out to the Truth team. Y'all know every sector I end up going in, I end up getting some real members added to the team that follows the cases. And I got hit up about it and said it was some new paperwork out on it, but it was kind of hard to understand. So yeah, that's what we're gonna get into. All right, so let's see. It's been so long. I don't even remember the last thing we did here. Okay, so this is all right. Let me see. Where do I want to start at? All right. Well, let's just start here. I think that's in order. I see it's a motion to dismiss. I don't want to jump straight to that without knowing what happened before that. So we're going to get into that first. All right, hopefully y'all can see it. Okay. So what was this? May 6th. Second motion to compel discovery. Blah, 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 blah. On February 7th, 2024, defendant filed his motion to compel discovery regarding the below proof of all efforts made by the law enforcement agencies to serve Mariah Hamilton with writ to appear at trial, including but not limited to skip traces, searches for employers, searches for enrollment in college, trade schools, or other educational institute. All efforts by and between the state attorney's office and Christopher Barrows to who is this? Hold on, y'all. Y'all know as soon as I start going live. Yeah, I don't know that person. So no. Thank you. I'm gonna send you to hey, what was the one? Oh well. I don't know that, y'all. Okay. All right. Email dated April 18, 2023 by and between Christine Bradley and Stuart Addison, prosecutors, right? Through any and all emails between the state attorney's office and Christopher Barrows to arrange Mariah Hamilton's appearance at deposition and or official proceeding, for copy of wit to appear at trial, subpoena, or other legal document. So let's just talk about that for a second. You may be like, well, why are they asking? Because that sounds real particular, right? Well, as y'all should know, because y'all should be up to date on my Melly content, but if you haven't, I'll kind of give you a little briefing. So the witness tampering case is about Mariah Hamilton, right? And the whole situation with that case is that YNW Melly allegedly used another inmate to be the middleman to communicate to YNW Bortland, right? To give information or past messages, like to guarantee that he's doing what he's supposed to do, in which, according to the state, is making sure Mariah Hamilton didn't appear at trial the first go round. So that is the whole witness tampering case. So the defense, okay, how I'm interpreting is wanting to know, okay, well, for us or for my client, right, to have tampered with a witness, to not have them come to trial means you did what you were supposed to do to ensure that that person knew they were supposed to come to trial. That person was served to come to trial. Because just because you have them on a list, if they was not subpoenaed, served, or attempted to be, then how can you say that my clients were tampering with a witness? So I believe that's a strategy, right? Now, if y'all recall, when Mariah Hamilton and her mother sat down with Law and Crime, okay? And remember, hold on, was that during that interview or was that at trial? I don't know. Was it in that? Okay, so let me say it like this. Whether it was at trial or it was in that interview, one of the two, okay? It was said by the mother, like, y'all didn't even try to serve me. You know what I'm saying? Like, y'all didn't come to my address. Y'all went to my ex-husband's address, different things like that. So she had already said, hey, it was issues anyway, talking about trying to serve me, and y'all was going to all these drastic steps to like put me on house, ankle monitor and all that. So again, I feel like that's the direction that the defense is trying to go in to challenge that they actually was trying to get Mariah Hamilton there. Because at the end of the day, if they didn't go through the official channels to do that, then how can you say a witness was tampered with? Whether you had an actual conversation, you have to have it documented. And that's why they're asking emails. They're asking for subpoenas. They're asking for these things because these are the legal channels you have to go through to make it an actual witness. Okay. All right. So next, it says February 9th, the court entered an order granting the defendant's motion 3, rather than provide a requested discovery or in the alternative, a response that the documents don't exist. The SOL filed a motion for rehearing, which was denied February 16th. Now, I'm gonna be honest. Outside looking in, it seemed like they probably ain't go through the proper channels because they're fighting it too much, okay? Because as it said, hey, we asked this already. Your court, your honor, you granted it, okay? Instead of them doing what you said, they came back to try to dispute it, and you denied it, and we still don't have it. Here we are filing another request, another motion. And I mean, that does look a little shaky, on a prosecution, because why you just won't, give up the information if you actually subpoena her or, so not looking too good, okay? For to date, the SOL has not complied with the discovery request. Now, remember, when you talk about discovery, you get really into Brady issues. And if you don't know, Brady violations are very serious with the when it comes to processing criminal cases and stuff. So we'll see what they're gonna say in their reply. Next it says the SOL is willfully disobeying the court's orders and should be held to answer as to why they won't provide a corpus and whatever the next word is of the witness tampering charge. And see, like I told y'all, I felt like that was the direction they're going with. Now this case is on one witness, Mariah Hamilton. So you got to have your ducks in a row, state attorney's office. All right, so it says, 6, it says the actions of the SOL are in bad faith in the defendant request that if the above described discovery request is not provided, then information filed by the SOL should be dismissed. Now we're making progress. So why we see a motion for dismissal on there. So, all right, hold on 1 second. Why can't you see it? How you saying? Okay, we good. All right, we got much. All right, so let me go back to where I was. All right, so the next document. So we already was here. We're gonna go to the response. okay? And it's 28 pages. Now, let's see what they had to say about it. Attorney's office. Okay, so that's basically what we just read on the last one. Okay, now they're getting into their response. All right, I'm going too fast. So let's start at 3, okay? So it says, the state was never noticed for this motion to be heard on February 9, 2024. Here go to the foolery, okay? Here go the foolery. Hold on. Then it says for 4. Yeah, I'm trying to do multiple things at one time. 1 second. So now it says the state emailed this honorable court judicial assistant confirming the motions that were believed to be set for this particular hearing date. Those motions included the defendant's urgent motion for status, the defendant's first motion to compel discovery filed on 2/6/24, the state motion for protective order of previously deposed witnesses, and the state's motion for pretrial ruling on admissibility of evidence. It continues on 5. At no point in time was the defendant's second motion to compel ever docketed to be heard. Further, the court also mentioned that all it had set for the day was the February 6, 2024 motion to compel. Despite not being placed on a docket for hearing, counsel for the defendant presented the motion to court. When this motion was brought up by defense counsel, the state very clearly stated that this motion was not set for today and that the state would like time to respond to this motion in writing. The court, without any indication of a response, simply said, "What's next?" And that definitely sounded like that judge, because he just be like, okay, whatever. All right, 7. The state was not noticed nor given a proper opportunity to respond to the defendant's motion, yet the court issued an order. So let's stop there. So at this point, this is saying, hey, yeah, they're saying that you ruled in their favor and that we're not coming through with the order. However, you didn't give us time to even respond. So you shouldn't have even issued an order if we wasn't even granted the time to respond, which is a good point. If this is true what they're saying, they should have had time to respond. All right, 8. On February 9th, 2024, the court issued a written ruling granting the defendant's motion without giving the state a reasonable nor meaningful opportunity to be heard, which is a violation of the state due process rights. See, that's why I said that's why I love actually criminal cases, the law period, because it's not as cut and dry as you think, right? And that's why y'all don't ever really hear me ever saying if somebody is really like if they did it or didn't do it, because that's not even what cases are about. They're about sticking within these rules to prove something. And sometimes, hey, you might can come up with a better story. That doesn't mean it's actually the truth. That just means your story was a better storyline. All right, so next it says, had the state been given a meaningful opportunity to be heard in this motion, the state would have made the following points of law and fact. So now we're about to get into what they're saying, what their whole stance is with everything, okay? So, all right. 8. Due to the inherent nature of the charge of witness tampering, the discovery from the defendant's original case, which is the homicide case, is relevant to the defendant's newest charges. Now, this is where it's going to be like they playing on a slippery slope, okay? Because, again, if you don't know, not up to speed, let me tell you, right? Currently, a lot of evidence from that case has been thrown out, right? So they're waiting on the Supreme Court to overrule the judge on it to get it brought back in. They're wanting to use that evidence, that discovery for this case. Well, at this point, you can't even use that for this case, right? Because it got tossed. So That then I feel like is a way to tie in a hold on this case too until the Supreme Court rules. So it then goes to saying the defendant moved to depose Christine Bradley December 18, 2023. The state objected. All right, so that goes. Let me see. What was their response? Now, we actually watched. Did we watch this? Anyway, we talked about it, though, previously, where they were going back and forth about if Christine Bradley was going to take the stand, if she could provide a deposition in regards to, you know, her role with not just the detective, Moretti. It's been so long. Can't remember everybody's names. But anyway, the detective, the lead detective on the case, which also had a hand in speaking with the witness in question on this case. So, hey, it's a lot going on. But the state, that new prosecutor, smooth now, because she's tying it in very well with not only legal precedent, but also a way to get what she wants. What to do, Loud Pat? So, I mean, I'm pretty intrigued by her stance, but it's definitely some food. Okay. So it says the state responded in open court saying that there are emails to prove what counsel is saying is unfounded and that the state is currently going through all of them prior to sending them out in supplemental discovery. This honorable court deferred ruling on the defendant's, whatever that says, request to depose Bradley in order the state supplemental discovery with those emails by December 28th. Okay. Then it says the state complied with the court's ruling and the supplemented discovery on December 21st. So they're saying, hey, we already gave it to you. We gave y'all what y'all needed per the court. And that's what they're saying so far. All right. So they said that this was dated December 21st, 2023. And it says on, see what case that is though, the 2019 case. What it do, Untamed? The 2019 case. So I want to have, are y'all catching a trend? They're not filing these things under the witness tampering case. They're filing them or referring to the other case, the homicide. What better way to connect two cases than that, right? Now, the loophole is going to be, is it a legal ruling that they can find that will be like, you had to file it on this case? You can't just say, oh, it's on the other case. It's on the other case if it's not filed on this case, okay? So that's going to be real tricky to see what the ruling will be on that. All right, so let me see what's next. Yeah. So it says, let it be clear, as this has now been stated repeatedly, that emails requested in the defendant motion has been provided prior to these motions to compel being filed, yet defense counsel continuously files motion requesting said emails. And again, that's gonna lead me to, again, see how the defense can respond to that. Because it seems like if the motion was filed on the 2023 case, then you have to file your reply on the 2023 case, not the 2019 case. But if I was thinking from a prosecutor standpoint, it's a way to continue to beat down your stance that both cases are related and that everything that's in the original 2019 case is going to be relevant to the 2023 case. Now, is that the right way to do it? I don't know. But it's intriguing to find out how this is going to play out. But again, the defense already filed a motion for the defense to dismiss. So they probably already said it, but yeah, we just have to go back a little bit. So if you're just joining me, okay, I appreciate y'all pulling up. Y'all know I've been out the way for about a month, really. But I'm back trying to get back into the algorithm. I wanted to reset my algorithm so that I can get back into doing other things. So yeah, so this live is just trying to catch up on some cases that we've talked about in the past, see what's going on in the metaverse. So if you are new here, hey, pull up, sit down, lay back, and just, hey, let me know what you think in the comments if any questions, okay? This was a request by one of my truth team members to break down the Melly paperwork because it was a lot of legal jargon that was kind of confusing to him. So that's what I'm doing. So we are currently talking about the YNW Melly witness tampering case, okay? Shout out to my moms, okay? And I was on time tonight, FYI, y'all. I was on time. Even though I almost forgot I said I was going live tonight, but that's neither here or there. Okay. All right. So now it says here the emails indicate there were times where Ms. Hamilton's counsel was unresponsive. And ASA Bradley had an investigator assigned to make sure he was okay. In fact, leading up to the days before deposition, ASA Bradley even contacted Ms. Felicia Holmes, Ms. Hamilton's mother's, due to unresponsiveness for her counsel. She also contacted other individuals that work with counsel to try and get a hold of counsel. Okay, Blue, what it do? Let me see. Further, the emails prove there were many times no one, including Ms. Hamilton's attorney nor her own mother, could allegedly get a hold of her. Now, that one is going to be tricky, right? Because, again, the question of the hour is, did you properly serve a subpoena to Mariah Hamilton? Did you properly provide her notice of this? Okay. Now this is why this is going to be so like kind of like edge of your seat to see what's going to happen, because it's one thing to know, like, to speak to the police at one point, right? But when you're talking about a trial, you have to go through a certain process to be an actual witness on the case, right? They can list you all day as a witness, but you're not an official witness on a case until you are served. So my question at this point, before we even get through the paperwork, is did they serve the attorney? Or did they, because if the attorney is saying, I don't know what she is, I can't get in contact with her. They're saying her mom said, I don't know what she is, I can't get into contact with her. Then how can you prove she knew she was going to be an actual witness at the trial? How can someone keep someone away from trial, right, if they don't even know they're supposed to be at trial? If that makes sense. If that's confused, y'all know I'll be trying to give y'all examples, but in a nutshell, that's kind of what it's swaying to. Why this is going to be important to how they replied legally as far as saying they couldn't reach her. Okay. Now, next says proof of all efforts made by all law enforcement agencies to serve Mariah Hamilton with writ to appear at trial, including but not limited to skip traces, searches for employers, searches for enrollment in college, trade schools, or other education institutes. Okay, here go their response to that. Now remember, that was a big piece of what the defense was asking for. So one, it says this is impossible to comply with. The state is not privy to what police departments and other counties do in order to locate Ms. Hamilton. Further, the state will never be made aware of the law enforcement techniques utilized by the U.S. Marshal Service in order to locate witnesses. 2, should Ms. Hamilton be taken into custody on this week and reports are in fact written, they will be provided in discovery in compliance with the state's obligation. Then at the bottom, the footnotes be very important, okay? It says counsel could also get the email between Mr. Addison and ASA Bradley from Mr. Addison himself as he is co-counsel of the defendant's homicide case, and they work together on his cases. And it sounds like to me they're saying, hey, they got what they need, okay? They just want us to do more work, and we ain't going for it, okay? Tell them to pull it out, they file. Unquote. All right, so let's keep going. Now, it goes on to say the state filed an amended motion for rehearing on this issue on February 13, 2024. On February 16, the court denied the motion for retrial despite the clear violations of the state's due process rights. Okay, look, they was buddy with the judge last time. This time they like, you moving a little funny. Hold on, y'all. All right. So a motion for rehearing is not sufficient meaningful opportunity to be heard. Well, that's what you asked for. So now basically they're saying, hey, we needed more time to prove or state our case and all that. Yeah, sounds good, right? That's gonna go into more legal stuff. I'm not trying to read it. I'm gonna just give y'all summaries. All right, so 16, they put it in bold, so it must be important to their argument, right? It says due process protections prevent a trial court from deciding matters not noticed for hearing and not subject of appropriate pleadings, okay? Thus, it is error to award relief that is neither requested in the motion at issue nor argued at the hearing on the motion, okay? So they said basically this here. We reverse the trials courts, whatever that is, order dismissing a 1985 felony charge. The record reflects that the state did not receive notice or opportunity to be heard prior to the rendition of the order of dismissal. So, in a nutshell, it's basically saying what they already said. How can you make a ruling if you didn't allow us sufficient time to state our case? Because they're saying, hey, we weren't able to state our case. And to be honest, and I kind of feel like depending on who the Supreme judges or judges are in this situation, it's going to be a matter of, do we pat the state on the back and say, it's okay, it's all right, you don't have to throw a tantrum no more, we know you're upset that the trial judge said no, so we're going to go ahead and say yes so that you can get what you want. Or they can say, hey, you had the opportunity to argue, however your argument wasn't strong enough or good enough, so it was denied. That's on you. Practice better next time. We're going to deny it. So that's it's going to be hard because it can sway either way on which way the decision is going to be made. But as I said before, when she asked that judge, the new prosecutor, and I don't even remember her name. I got to catch up on everybody's name again. I forgot her name. But anyway, when she asked for more time and that judge said no, and remember, I don't even think it was a week later, the new case came about. And what did I tell y'all then? This is her way of getting more time. This is her way of getting what she wants. And now, again, the first go round, the defense wasn't able to be as successful as they are this go round with getting evidence thrown out. So she's like, you let it stay the last time. Why is you throwing it out now, right? So she's like, no, judge, we want you to redo it and give us what we want. He didn't want to, so they were like, okay, we're going to hold it up. We're going to go to the Supreme Court. Because you know what happened? If you recall, at the beginning, the first time, the hold up before the first trial was the death penalty part, and it went to the Supreme Court. You know what I'm saying? That's the way to buy time. And that one was on the defense. So, again, the Supreme Court one is filing. Yes, they want the evidence back for sure. So I ain't saying they just doing it for time. They definitely want the evidence back. However, don't think they ain't over there thinking of a way or backup plan if the Supreme Court still denies it. Because again, it's just gonna be on how they feel. Like I'm pretty sure, to be honest, like if it's like a old school value judge, they'll probably deny it, right? Because they'll just feel like, oh, you had enough time. Like you just didn't use your time wisely. Like the newer judges that's more into the like newer way of thinking probably been like, yeah, you should have had more time. So it just depends, to be honest. I really don't. It's so up in the air. That I personally couldn't tell you what I think they will go with. I just feel like the thought process would be either or, whether you're old school way of thinking or new school way of thinking. All right, so now it says, despite the violation of his due process rights and despite the defendants accusing the state of willfully disobeying a court order, the state has turned over what it can turn over prior to any order from this court as laid out above. At this juncture, the defendant's motion is repetitive, frivolous, and an abuse of the court's time, therefore should be stricken. That's a deep way to end it, okay? Let me see what's next. I think they just put a lot of the filings on it. I thought I had to sneeze. I think I did. Okay. A buckaloo. That's a name, buckaloo. All right. So these are the emails. I can't agree to the pretrial ruling motion filed by the state as it's concerning evidence that has never been provided in the 2023 case. I knew it. See, that right there already set the tone. They're like, yo, yeah, we may be working on the 2019 case, but we're literally talking about the 2023 case. Y'all need to follow the 2023 case. Just saying. Said we would need to hear the motion to compel discovery and actually have a discovery that is part and parcel of the state's motion. And to be honest, I'm interested into seeing if they're going to let the state do that. Because that is kind of crazy, though. Like the motion is literally filed on one case, but you're saying, oh, it's already on the other case when the cases are technically not tied together, like per se. It's two separate dockets. And remember, they had a whole showdown in court about it not being the same case and this and that. I told y'all that was BS too when we broke that down, but you know, y'all don't be hearing me sometimes. Okay. What's next? Yeah, Alex ain't playing. She's like, I'm gonna get my way or nothing. Is the defense trying to throw out Bortman's statement? We're not on that case yet. We're on a witness tampering case. But I do believe Bortman's attorney is trying to throw out his statement. Like, I do believe that's who's actually trying to throw it out. And if I recall correctly, now y'all know I have not done a Melly dive in a while. But if I remember correctly, they had a stance of when, okay, so little side note, and we'll get back to that. So if y'all remember, Bortman gave one statement. That's the audio that we heard at trial, the audio that got leaked. That's the only statement that he gave, okay? That is the basis of the case, right? Remember, Detective Moretti is, y'all correct me if that's not his name. I think it's Moretti. He basically used that as his foundation to poke holes in the statement to make their case, okay? So Bortman's attorney is like, well, that was a victim statement or a witness statement, right? That wasn't a confession. That was a witness. You were interviewing him as a victim at the time. He was not read his Miranda rights, none of that. Now he's, guess what? A defendant. So the question is up in air, like, can you use a victim statement against that victim in a criminal case? To my understanding, I don't think they ruled on it, but we can check it out. But that was a while ago. So to my knowledge, only Bortman's attorney is trying to get thrown. I'm not sure if Melly attorney is too. Thank you, Granny. And same to you, okay? Hey, I was lit on Mother's Day. I had a Mother's Day party, and we had a good old time. I hope everybody had a good time. All right, so I'm really not gonna go through all the emails and stuff because I mean at this point, the whole concept of it is, will they get away? And I'm saying it like that, but I don't really know how to like really better say it. Will they get away with filing their paperwork on the other case than this case? You know what I'm saying? So I don't know. Let's see. So okay, on May 7th, something was filed. Let me see. What is this? All right, so Mariah Hamilton's certificate to procure state witness. And to be honest, I ain't gonna lie. I'm not 100% sure if that actually means that they have officially served her or if that just means they're going to. So I don't know about that one. However, it's there. It's not what they originally asked for. It seemed like maybe that's something new. All right, let's go to this one. Motion to dismiss. All right. Okay. All right. It says Jerome did unlawful and only engage in misleading conduct and on offer pecuniary benefit and or gain with the intent to this information defines the subject matter official proceeding and trial. Okay. So they're just saying everything we read in the first document. So the argument is this. Oh, here we go. The certificate on its face recommends process be issued directing Mariah Hamilton to appear as a witness in the state of Florida for a trial the week of March 7/22. And Mariah Hamilton be required to continue to attend and testify for a period not exceeding 60 trial days. Loophole. That's what I tell y'all. You like, for those who are actually like a fan just of the law, it's because like it be so mind blowing how technical things can be, right? Because when I say that, you see how that's underlined? Because that's important. You know why? Remember, the first trial was supposed to take place in 2022. But remember the whole Supreme Court thing with the death penalty? So it didn't. So that certificate, as stated there, was for that trial. And you see, for a period now to sit in 60 trial days. The trial never happened. You know what I'm saying? Never happened. Now, my thought is this. Is there a loophole that the state can come back to where they can say, well, yeah, it was for that. However, it stood in place since the trial didn't take place to then go into the actual trial that took place in 2023. But, you know, I couldn't tell you what legal person they can say on that. I'm just saying that will be the only way I can see how that went and stand up, because that does make sense. Like, if she was served for the trial that never happened and it only is valid for 60 trial days, then it wasn't no witness tampering now in 2023. But let's continue. Now, it says the certificate can only make a recommendation because in accordance with Florida's statute 924, the Florida court cannot actually compel the out-of-state witness to take any action and cannot impose sanctions against the out-of-state witness for failing to obey. Ooh. But then that would then, well, hold on now. Because in the earlier paperwork for the depositions and all that, and they had a Florida address for her and her mom. They had a Florida address. Well, they're stating that statute, and that means, in my opinion, Mariah Hamilton wasn't living in Florida. So if that's the case, then they were trying to serve her at a non-working address, knowing she doesn't stay in the state, right? What is this? Where it come from? That's interesting. All right, let's keep going. Because I've never seen an address on file for them, or for her, that wasn't in Florida. Because you know, so that's interesting. Then it says under section 942.03, the Florida court merely issues a certificate to the sister state court where the witness is located so that the sister state can make certain findings and issue a summons to the witness who is appearing before the court. All right. The certificate is not a warrant or subpoena. Well, damn. Okay, so that crosses off my first guess of what that certificate stood for. So it says the certificate is not proof as required to prove that Mariah Hamilton was summoned to attend the trial that occurred April 10, 2023 and July 22nd, 2023. More importantly, the certificate expired 60 days after March 7, 2022, and therefore is not relevant to the dates as defined in the state's information. It is undisputed that Mariah Hamilton was never subpoenaed by legal process to appear at trial. It is undisputed that the court record in the case number state of Florida versus Jamel Demons case, and then give the case number, is devoid of any proof that subpoena to attend the trial was ever issued, perfected, or attempted to be served either by the defense or the state of Florida or any other state summoning Mariah Hamilton to testify at the trial between April 7, 2023 and July 22nd, 2023. It is undisputed that the state of Florida made noted attempts during April 10, 2023 through July 22nd, 2023 to serve Mariah Hamilton with summons or warrant to attend the trial, as there was no subpoena or warrant to serve. And that's right, because they put all their eggs in the basket of the mama. The video is available when we broke that down, so that is true. The SOL has been given the opportunity to provide evidence that will support charging the defendant with the crime of witness tampering, and after several months of delay have failed to do so. So, in conclusion, it says the application of the law to the undisputed fact shows that the state of Florida has not and cannot meet the factual burden of establishing a prima facie case of witness tampering. Accordingly, dismissal of the information is warranted. Now, again, I'm going to say this, okay? For my opinion, if it's not a legal precedent that they can say to why the original certificate for the trial that never occurred in 2022 should still remain valid for 2023, I don't see how they're going to be able to argue the facts of this. Because if, okay, they never served her, never did anything, and they're only dependent on the certificate from 2022, how can you argue that? Like, that's going to be one. Well, that's going to be interesting. I hope Law and Crime stream that one, because I would want to watch that one. Let's see. Another document, motion to compel. All right. What's this is about? Oh, give me a second, y'all. My bad. Probable cause affidavit. think that's the same thing. Yeah. Okay. So basically, this is going into the same thing we just talked about in their first motion, plus the deposition of Christine Bradley. I don't think they're gonna let Christine Bradley be deposed though. But that's just my little opinion, you know. Yeah. Oh, they break it down too. Despite the probable cause of saying April 18, 2023, emails were signed by the defense. Did not provide any emails dated April 19, 2023. Rather, the next email was sent by ASA Bradley 10 days later on April 28th. And I think, if I'm not mistaken, I think this was in the paperwork back then too. But all right. So I don't feel like going through them emails. I'll do it in the video version of this. So it seems like it's going to be all on technicalities at this point because the defense is saying, hey, y'all are saying you sent what you needed to send to us about the emails that prove your stance for this case. But in actuality, you're not proving your stance because guess what? It's not, the dates are not matching, you know. Interesting. I think this, y'all thought the first go around was interesting. I think this go around definitely gonna be interesting, and it's definitely gonna be survival of the fetus in the legal field. Like it's gonna be something for sure. All right. Let me see what else they got on docket here. They don't have nothing else on the docket right now. Let me check. Can't type. Let me check the other case. That's gonna be interesting though. To see what they do with that case. All right. And yeah, for y'all that came in on telling, I will do a condensed version in the video, kind of recapping, you know, what I just went over with less reading of the paperwork. I'm gonna give y'all a summary. So I'm gonna go back to how I used to do it, where we'll break down the paperwork on live, but in the videos, it will be more so the recap because a lot of the true team that watch the videos don't really be paying attention to what their paperwork be saying. But y'all can always check it out on the live. Okay. All right. Let me see here. Now this is going now. See, this will be my whole thing, right? Is this the same thing that's on the other one? Oh no. Okay, because I was about to say, now how y'all finally filing it on the other one, but not this one. So this one is basically stating that the attorney files this limited appearance hearing for the purpose of representing material witness Felicia Holmes for a motion to remove GPS monitor. That is crazy. They filed that like not long after the first trial ended. This lady still has a GPS monitor. That's absurd. That is absurd. Like, oh, that's absurd. See, that shit there is crazy. Like, I'm not even the criminal in the case, and y'all got me on a GPS monitor for years at this point. I think what since the end of 2022, something like that, if I remember correctly. Yeah, don't quote me on it, but that's crazy. All right, that's basically it. Cause like I said, I just did a video like 2 weeks ago about the homicide case and where that stands is as of now. And as of right now, it's not moving. So I think we're pretty much up to date. If y'all ain't got no questions, that's that. They got another court date coming up. Ooh. Not as of right now, they don't. Not Professor Truth. That's funny. All right. So, I mean, if y'all ain't got no questions on it, like I said, I'll do a, and it won't be tonight, I'll be honest. It ain't gonna be tonight. But probably tomorrow, I'll drop the video condensing it, just giving an overview of where it stands. In summary, for right now, the witness tampering case is currently has a active motion to dismiss. Okay. And the whole stance of it is, hey, y'all only provide a certificate of service from 2022 when the first trial was supposed to take place. And that certificate of service is only valid, okay, for 60 days, which definitely had lapsed by the time the trial took place in 2023. Rollo, what's up? Okay. Y'all keep y'all eyes out. Me and Rollo Shorty got an interview dropping soon. And y'all make sure y'all go subscribe to his YouTube channel and check out his music for real. He definitely got a story. And guess what? He got a legal story too. So y'all know we're gonna have to dab into that, okay? But that will be coming soon. So yeah, so right now it's just the chaos continues. But I will say it's a good stance though for the defense. But I will also give the prosecution props on how they are trying to come at it. However, I think if they don't find the right legal remedy to throw at it, they can definitely lose this case. Meaning it could get dismissed. And I'm talking about the witness tampering case. The homicide case, I mean, I can't even try to even say where it's gonna go because until the Supreme Court rules, and it's kind of hard to even know what they're gonna rule on. You know, it's kind of like up in the air.
Loudest is the weakest. Give a fuck about what they scream.
Holla!
Shout out Mickey. Mickey, you gonna be big. Like
I'm trying to conquer the world. Coming from where I come from. They doubted me, but I came up.